Hey again, everyone. It's Rob Ryder, and it's Saturday, October 12th, 2019. Did you enlist? Well, then it's time to insist. Did you know, this is a fact, that we, the enlisted, have never been separated from the United States Armed Forces? We're still in the military. And so, hey, that's what this video is mainly about. It's for veterans and people in the military and people who know people who are veterans and were in the military, which is pretty much everybody. So, over the last bit of time, I have done a number of videos, right, having to do with military issues from the veteran side and the DoD side. And so you don't have to go all the way back to like the DoD is the fourth estate, which was 3 months ago. If you search on my site, Rob Ryder, do them by upload date. And then pretty much all these have to do with what I'm trying to condense into a very short video, relatively short, about things that are. And, hey, the only reason they are this way is because we haven't got them changed yet. See, once we know it's an error, an administrative error in a record, well, now you can have recourse to get it fixed because you don't need to put up with records that have errors when you're a veteran. Right? So let's go get the errors fixed. So what is all this about? Well, there are errors or omissions in official records. There have been acts of bad faith and breaches of the public trust, which stand between you, me, we, and the entitled benefits and privileges Uncle Sam intended for us. You, me, we must insist on correction. So, the classic example is people are fighting VA benefits. Well, it's really not a benefits issue. The issue is there's a frickin' error in the record. If that error was fixed, there wouldn't be a benefits issue. You would just get the benefit. So quit taking it to the benefits people to have them adjudicate it. And take it to, it's actually the Secretary of Veterans Affairs that has the authority to provide equitable relief when administrative errors, the federal government or its employees are the cause of benefit denial. And your DD-214 is evidence of these errors and omissions. Now, all of these things I'm talking about were covered in these, various videos I did. But the main one would be, does the DD-214 fraud equal UCMJ violation? And in there, I'm going through my DD-214 and comparing it to the regulations that were written on how to fill out the DD-214. And, a regulation is an order. It's a written order. Well, I didn't follow the order. So it's an administrative error. Well, the Secretary of Veterans Affairs can take care of all administrative errors, right? This is the thing. I'll show you the law that says so. But it doesn't just have to be about a VA claim. He can take care of all errors caused by federal government or its employees that would cause a benefit denial. And, you'll see that as a veteran, you have both benefits that come from the DoD and then benefits that could come from the VA if you claim them. So let's get into that. It appears from circumstantial evidence that we, the enlisted, are voluntarily held over past our release date for medical reasons, eventually being permanently disability retired, right, through the DoD, or retained in some reserve capacity, but either case is still in the armed forces. So what a DoD retirement is not a VA disability compensation. And to get DoD retirement, well, you had to have a DoD ID card, right? A DoD ID card is proof of entitlement to DoD retirement. Our DoD ID card should be a Geneva Conventions ID card. Now, I'm talking about enlisted veterans, right? But I'm saying anybody who's in the military, we should all have that's called the United States Armed Forces Geneva Conventions Identification Card. And I've shown it in other videos also. So, that's the one we should have, and they don't want to give it to you. And the reason is, as you start to find, this is what got me on this path is, well, there's errors in the records in what's called the Deers record, Deers, Deers record. And so on mine, it has my birth date is September 1st, and my birth date is September 5th, and it has my name as Rytlewski, Robert A., instead of Rytlewski, Robert Allen, like it shows on my DD-214. Right? I mean, I'm okay with them using my name that way if it says last name and first name and it's used that way. But somebody made an error in the record and did it just with an initial. So there's my error, right? I got an error in the records. Hey, you guys got to fix this stuff. And so now I understand I should be able to go to the Secretary of Veterans Affairs to get it figured out. But hey, these are all just things that really affect every veteran, and why we need to get it fixed. So we should have a Geneva Convention ID card. You should still be in the military with a Geneva Conventions card, and that takes you out of the local authority. It's your proof that you're under the UCMJ. So, the policeman asks you for your ID, you hand them your Geneva Convention card. DOD retirement, now this is DOD retirement, it includes enhanced Social Security benefit and a survivor annuity. So it isn't just, you serve 20 years and you get a retirement. No, they have this enhanced Social Security that they did for everybody who served, where they kicked in an extra $100 a month into your Social Security, where, you were paying, God, I don't know, $5 or $6 or something maybe. Right? So it was a substantial amount back in 1988. And that's been going in and, it's sitting in an account. Well, the only way to get that is to have the ID card, because it's part of the DOD retirement. And DOD retirement proof of entitlement is a DOD ID card. So there's where the error is that needs to be fixed. Now, both DOD retirement pay and VA disability pay are enlisted entitlements. They're not the same thing, and you're entitled to both. The United States is under military rule, and we, the enlisted, should be recognized as office holders, federal, in the military government. Sure enough, right, there's gold fringe flags in courtrooms. President Lincoln declared martial law in 1863. It's never been rescinded. Yeah, we're under martial law, military rule, and we are office holders in that government, except for being denied our place because they won't give us our card. But beyond that, I mean, this is the reason America's so fucked up, right? Because we don't have our official office, and no alleged member of Congress has sworn an oath of office that satisfies the Constitution. Nor any federal judge, nor administration agent, nor alleged commissioned officer. They all take an oath that says, "So help me God." Right? And once they did that, they violated the Article 6 of the Constitution, which says they got to take an oath that no religious test. And the oath is actually in another law. It's 1 Stat, STAT 23, right? Where they actually wrote the oath. They said, this is the oath that satisfies the 6th article of the Constitution. And nobody's taken that oath. In fact, Donald John Trump needs to take that oath. He hasn't done it yet. So Donald John Trump needs to take an oath of office redo, and he needs to do his 2 oaths of office, the one that's in Article 2 and the one in 1 Stat 23, in his full legal name with no religious test, and, then he can be the President of the United States. And we, the enlisted, are still under an oath of office to the President of the United States. And we would have completed the chain of command that is supposed to rule the republic under a military government. Right? We'll be the peacemakers. When you call, somebody will pay attention because you got an ID card. Right now we don't have it, so we can't fulfill our duty to God and country. Amen to that. We get to participate. Now, we, the enlisted, also have an association that has a federal charter. And it's not the American Legion. It's actually the the Retired Enlisted Association. And that association has a federal charter, and it says that its powers are basically whatever it writes into its bylaws. But you go read the bylaws, they haven't given themselves any power yet. And it's like, well, yeah, you could give yourself all the same powers that any other corporation has, and then you would have standing when you brought something to court. You know, if the courts are all operated in a fictional corporate structure, well, you would have your fictional corporate structure to take into the same venue. So now you would have standing. And the thing is, again, that they haven't given themselves any power, and all these are things to be built on in the future. But I wanted to point them out because I had come across them. I said, wow, we have lots of things we could do to help ourselves, and we probably should try to do it. So until it gets figured out, will you donate to help keep the lights on? PayPal always works. That's Rob Ryder at AOL.com. Or there's my mail address, Robert Allen Ratlewski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. Phone number, email address, it's all there. If you need to contact me, go ahead. But I want to do a video just on some of the different documents I have found over these last number of videos that have to do with this particular subject, and how we, the enlisted, don't need to have anybody's permission to do what needs to be done. We just need to get it done ourselves, and the tools are there. It's a group effort. I'm not supposed to do it all myself. I can't do it all myself. There's people in the military and that were in the military that have special talents that can be called on. If they were to understand what the problem was, they would know where to go to get the solution. So I'm just trying to identify the problem. And this is the problem, although it really isn't. We, the enlisted, have not ever been separated from the United States Armed Forces. You are still in the Armed Forces, and therefore you're supposed to have a military DOD ID card, Geneva Convention style. So what happened? Well, that's what we're going to look at next. So give me a second to load up a few pieces of paper. Although this program is working really slow, so hang on a second. Testing. 1, 2, 3. Okay, I think we're working. So I got a lot of things open I wanted to show you. It's making my computer run slow, so this program I use to make these videos is running kind of slow. And just want to make sure it's on. It appears to be on. Okay, so this is in the Department of Defense Law of War Manual. I'm thinking if I close some of these bigger things, my computer's going to work better. So we're going to get the big documents out of the way. In Section 943, issue of identification cards to persons liable to become POWs. See, we're already under martial law. We're already at war. This has already been hashed out between Lindsey Graham and Justice Kavanaugh during Kavanaugh's hearings, Senate hearings, that he understands the difference between these two forms of law, under armed conflict and under criminal, and that we are at this time under an armed conflict. Right? This has been going on, he said, since 9/11, 3 days later, when they enacted whatever the act was they did, whatever that one was. I can't remember the exact. Was it the Patriot Act? I think it was. But, since then. So, and that's when Congress signed on to it. Anyways, so we're at war right now. The Civil War's never been decided. So we're at war. Martial law since 1863. We're at war. It's, domestic and it's international, but we're at war. So we should have one of these ID cards. We could become a POW at any time. Right when the policeman picks you up, that made you a POW because he's taking you from the federal jurisdiction into the state jurisdiction. And it says in here that you would have one. And Goes on to say that in accordance with this requirement, DoD practice has been to issue all ALL members of the U.S. Armed Forces identification cards that indicate their status under the Geneva Conventions. And sure enough, they have cards that say it. United States Armed Forces Geneva Conventions identification card. Well, that's the one we'd like to have. But right now, they won't give you any of them. An individual's loss of the identification card issued by a state party is not basis for denial of POW status. So this is why I tell people who are in the military, if you're going to court, tell them you're in the military. Or if you're a veteran, tell them, because when you go into the courtroom, they're going to have a golden fringed flag, and that's an Army flag. That's a military courtroom. And say, if this is a military courtroom, then you demand to have trial by court-martial. And you change the whole dynamic in the courtroom. I'm sure it'll happen. You just have to try it, right? You got to have a little faith. Go try it. But those are your telltales, man. This is wake up. You just walked into a military courtroom, right? What does that mean to you? Well, if you're a veteran, it means to you, well, I'm claiming to be under the UCMJ, and I'm entitled to court-martial. And this isn't a court-martial, so this is the wrong venue. Because there's lots of different kinds of military courts. But anyways, I'm just showing you, we should have an ID card. According to the DoD Law of War Manual 2016, right there, Department of Defense Law of War Manual. That would be the Department of Defense, June 15th, updated December 2016. Good enough. What else do I have to show you? What does it say in the UCMJ? Well, it says in Article 2, persons subject to this chapter, right? It goes through all the people that you would believe have been told are subject to the UCMJ. And then you get down to this part B, right? Those were all A's, A12. Now we're into B. Voluntary enlistment of any person who has the capacity to understand the significance of enlisting in the armed forces shall be valid for purposes of jurisdiction under subsection A, and a change of status from civilian to a member of the armed forces shall be effective upon the taking of an oath of enlistment. And from that day forward, you are in the armed forces. And you knowing that is something you can use in the courtroom. So this is why, I'm saying, hey, we have powers and authorities that we're not using. We need to figure out how to use, because they're not going to come tell us, right? Either we're going to figure it out, or we're going to be rolled up and spit out through the Chinese war machine, right? Because that's where Nancy Pelosi and gang are taking us. We've sold out everything to the frickin' Chi-coms, as Alex Jones would call them. So if that's what happened, well, so be it. I know something happened, right? They're stealing our entitlements and putting them in, using our accounts and, putting it into their accounts. They're putting it into funds, and then they're administrating the funds, right? So because the fund is big, then every transaction is big, and they make more money. So instead of giving you what's yours, they just keep it in the fund. Oh, you wanted us to put that in deposit, right? You didn't want to spend it. No, we'll put it in deposit. And so when you look at the military retirement fund, they pay out $50 billion to $60 billion a year, but the fund is almost $1 trillion. Well, why is there so much money in the damn fund? The answer is they're not paying it out. Because this is one of my premises here, that we're under some kind of, like myself, I'm under some kind of disability retirement that I don't know about. And that money is going into the retirement fund, along with everybody else that's in the same boat that I am. And although it's ours, we're not getting the advantage of it. Now, there's laws that are passed, and I probably should go find it, that says once the armed forces gives you retirement, except for fraud on your part, it can never be taken away. So if they decided to give me medically retire me at 8 years of service, well, so be it. It's mine. I claim it. They did it, right? I didn't do it. So that's the mindset, right? That they have done things, people behind the scenes, with our entitled benefits and privileges that they're using to their benefit, that if we could ever figure out how to take them back, they're already there and they're our benefit. Yeah, it's kind of shit you got to, ponder a bit. But here we are. So this is Title 10, Armed Forces. 506, regular component, extension of enlistment during war, and enlistment in the regular Army, regular Navy, regular Air Force, regular Marine Corps, regular Coast Guard, in effect at the beginning of a war or entered into during a war unless sooner terminated by the President, continues in effect until 6 months after the termination of that war. And so once you enlisted, you're always enlisted. I enlisted during the Cold War time, and then when I was in, they started the war on drugs. And God knows how many different wars that were started during that time. Those are the two big ones that come to mind. And I know that the Cold War, they actually, at some point, were handing out certificates, saying that was the end of the Cold War. Thank you for your service. Between 1946 and 96 or 92, something like that. Maybe it was 96. They called it the Cold War. So those times are wars as far as the system is concerned. And if you went in, like myself, during the Cold War, and there had been no other wars, I would not have been released until the end of the Cold War. But as it turns out, we had some more wars, so it extended it, right? And the war on drugs continues, the never-ending war. So you'll always be in. Okay, so here's the other one now. Extension of enlistment for members needing medical care or hospitalization. If you look at people's DD-214s, you'll see that they never check the box saying they had dental. And that's where this comes in. An enlisted member of the armed forces on active duty whose term of enlistment expires while he is suffering from disease or injury incident to service and not due to his misconduct, and who needs medical care or hospitalization, may be retained on active duty with his consent until he recovers to the extent that he is able to meet the physical requirements for re-enlistment, or is determined that recovery to that extent is impossible. This section does not prevent the retention in service without his consent on an enlisted member of the armed forces under some other subsection 972 of this title. So they can get you either way. Either you consent or you don't. And I had shown in the previous videos where, they get your consent by having your commander sign it. Because while you're in, they've already taken over your identity once you join the military. They have your power of attorney, right? They can sign for you. So it's for your own good. That's what I look at it. Thank you very much. Somebody signed for me, and they put me into some kind of determination that recovery is never possible. And I've been disability retired for a long, long time. And that's making up part of this balloon that is the military retirement fund. And it isn't just me, it's every veteran, right? That's all our balloon. We got to figure out how to pop it. Okay, so there's some good, deny that. Now, this is the Michigan Militia Act or Military Act. We'll look at it in a section, but state military establishment. Composition, organization, and unorganized militia. The organized militia of the state, when collectively taken, shall be known as a state military establishment and constitute the armed forces of the state. The organized militia consists of the Army, National Guard, and Air National Guard and Defense Force when actually in existence as provided in this act. The unorganized militia consists of all able-bodied citizens of this state, all able-bodied citizens of this state, and all other able-bodied citizens who are residents of this state, who have or shall have declared their intention to become citizens of the United States, and who shall be 17 or over, not more than 60, and shall be subject to state military duty as provided by this act. If you're between the ages of 17 or 60 in the state of Michigan, male or female, you were put into the state's militia. Right? So, now once you're in the militia, well, then there's different levels in the militia. Most people in the militia are just in, they've done the selective service part of the militia. Went down, selective service, got registered. Now, I've done videos on that where, well, that isn't all they were supposed to do. They were supposed to classify you and give you a test. But they don't do those. And that was supposed to be done by a local board. It'd be like going down to the American Legion and sitting before a board and taking a test. And right, that's what the veterans would be doing. They would be checking you out. And then signing off on your paperwork. That's what I'm saying. We're not using these veterans entities like the American Legion or the Disabled American Vets or the Veterans of Foreign Wars or the Retired Officers Association or Retired Enlisted Association. We're not using them the way they should be used. But back to what's happening. So what they do in the Selective Service is they don't classify you the way it says to do it in the Act. They just arbitrarily give everybody a 1H classification, which basically means you're not available to be 1A, which is the one you need to be in to be unrestricted military duty. So you're not available for military duty, right? They've stripped you of your civil rights or liberties by taking away your status of being registered, right? You went down to register, but they're taking away its effect by giving you the status of 1H. And they give it to everybody, right? Go back and look. You'll see a video or two that's just on that subject. My point is, everybody's in. And if you're in the militia then, and you were put into the selective service system, then all your hospitalization is supposed to be paid for. You just use the emergency room. Right? For anything that you have, you go to the emergency room. It's all paid for. It's part of the entitlements you get for having registered in the first place. So all these things are already taken into consideration. It's just we're not getting the benefit of them. Somebody else is taking those benefits. Okay, so jeepers. I don't want to do that. I just want to close it. No, don't save nothing. Okay. This is the... I don't want to do that yet. That takes a little bit longer. I'll just show you some examples, right, of the different DD-214s. So this is... close that. All right, this is the one they send to Veterans Affairs that you can get for the state. The 6 out of 8. There's like 8 different copies, right? This is copy 6. And it's got this, blacked out part here, which is in copy 2 and copy 4, I think it is, and copy 7, right? But it's not in the one that went to your state. And it's not in the one they give you, that's copy 1, which stops right here below this member unavailable for signature. On mine, that's what it says. But, this part down here isn't on that first copy. And so this, some really hokey shit going on with DD-214s. And as I've shown in my past videos, where this would be all the stuff in, right, does DD-214 fraud equal UCMJ violations, you would find me speaking about the fact that all this information down here is wrong. right? This separation code is supposed to use the exact narrative that's with it in a manual, and it's not using it. And the separation code and what is in the manual would make it sound like I couldn't be re-enlisted. Yet I have a re-enlistment code that says I can be re-enlisted. Right? So there's all these errors in this record. I wasn't there for signature, so they say. I didn't get dental care, right? This is 10 U.S.C. 507, right? Because dental care is considered medical care in the military. You may not be in the hospital, right? But it's at the hospital. You're just not inpatient. You're outpatient. And on mine, the fact that it says NA up here, number 9, that seems to indicate that I was, well, either I was kicked out or I was disability retired. So, this is one of the things we have to go through. This is where the mistakes are, to take to the secretary to say, hey, man, this shit's wrong. You have to get it fixed. Because it doesn't say just, VA records. It says, no, all records, right? You got any record problems, errors in records, the secretary can get them fixed. And so it's just, well, how do you get them to the secretary to have them fixed? Well, that's what we're going to work on. Well, how do you get them to the secretary to have them fixed? I think one way is you take them through the health side of the VA and make it a health and welfare issue, because these errors are keeping you from getting all your entitled benefits. Well, that's, a health and welfare issue. And if you're already the patient of one of these VA hospitals, then the administrator is your administrator. And so I'll show you an example of what I wrote for somebody to put in to see if they do it, right? But that would be one way. So I'm planning on doing this myself. I just haven't done it yet because I'm doing a case in the Veterans Court for the same reason. But to take this DD-214 that I know has errors and put them all down on a document and send them to the administrator of my hospital to say, there are errors in my DD-214, and according to 38 U.S.C. 503, the secretary has the authority to get these things fixed, right? And the health has its own chain of command to the secretary outside of benefits. So, okay, well, that's what I'm saying. I don't really have a plan yet. I just want to show these things because to me, they all come together. And, is what it is. Now, you may want to get a pencil and write these down. Right? This is these different Department of Defense manuals that I've shown in previous videos. So this one is 134102, which has to do with the DEERS reporting system. Defense Enrollment Eligibility Reporting System. And this system has errors in it. Right? They got bad information on you in the DEERS system. But they wouldn't let me see my DEERS record to get it fixed. But this is the system that has my birth date as September 1st. And the way you'd know this is if you were in and you had like you can go to MI Connect and get through the DOD, you can get in if you were in the military, or you can go through the VA and they have these two different systems. And one of them has my birth date as September 1st. It has my name as Rytlewski, Robert A., not Rytlewski, Robert Allen. Which normally I just wanted to be Robert Allen Rytlewski, but because it says last name, first, and that's what they did. But Robert Allen is my first name. I don't have a middle name, right? Never have a middle name. No, I don't have. Then you can never have a middle initial, right? You have a given name and a last name. And when you look at it on your DD-214, it shows that because it has your last name and a comma and then whatever the rest of your name is. And if you look at the instructions, it has last name, comma, first name, comma, middle name, right? But there's no comma. Yours only has one comma, so it ended after first name. But, yeah, this is where they use this to get you your to prove that you are eligible for a DoD ID card, right? Which comes out of, now this is a Department of Defense manual, 1000.13, Volume 1 and Volume 2. And it talks about the different kinds of, this is the one that has the different kinds of cards, if I'm not mistaken. Yeah. ID card descriptions of population eligibility categories. You got your Armed Forces, United States, Geneva Conventions ID card. Really, this is the card you want. All right, this CAC, right, so it's a common access card, is the primary ID card for uniformed service members and shall be used to identify the member's eligibility for benefits and privileges administered by the Uniformed Services, DoD, right, as described in Volume 2 of this manual. So to get the benefits and privileges that are in this other, section or Volume 2 of this same manual, you have to have this ID card. And this is the ID card we do not have right now. Now they have these other, see, they have one now that they want to say is the CAC, which looks like something you'd pin on your shirt, right? That's just a style of a CAC. This just said, this is a CAC, right? An Armed Forces, United States Geneva Convention ID card. Well, they also have a U.S. DoD or Uniformed Services ID card. Notice it didn't say Geneva Convention, but it still says that's a CAC. Then they have a U.S. DoD or Uniformed Services ID or privilege card, which doesn't say it's Geneva Convention, and it's a CAC. So there's many kinds of CACs, right? What you want is the one that is a United States Armed Forces Geneva Convention ID card. This one here is for civilians. So it isn't ours. Then they have a DD Form 2, right, which is an Armed Forces United States identification card, reserve, but it doesn't say that it's a Geneva Convention card. But they have a 2S that says it's a Geneva Convention card for the reserves. So if you're in the reserves, does your ID card say Geneva Convention ID card on it? If you're in the reserves, can you send me an email and tell me if it does or not? Right? courtofrecord@aol.com. I never get around to reading the comments. There's just too much to do. So that'd be the best way. So, and then they have a 2S res and they have a 2S ret. One's for before you're 60 and one's for after 60. And basically these look like the ID cards I remember when I was in. Just, the front is a different color, but it's the same style card that you carry in your ID in your wallet. Not the one that you would clip on your shirt. Right? That's the style CAC that we need, and that they're called a DD Form 2S. And that, the 2S is a Geneva Convention ID card. And that's really what I want. I want a card that satisfies the Geneva Convention. Because if it satisfies the Geneva Convention, well, now you are a protected person under the Geneva Convention at a time of war. Right now we're not, because we're not identified. Right? We should have the highest status you can get at a time of war as a prisoner of war, but instead we're seen as unprivileged belligerents. And they have their own court, right? That's where they're going to. And that's where they're taking us, because we don't have the ID. But if you tell them when you're in there, well, I'm protected under the Geneva Convention, and especially if you're a veteran, say that you demand a trial by court-martial, they'd have to give it to you. And it's trial by court-martial that protects your rights to due process. Because the Constitution's been suspended. It may protect your rights to due process, but it's been suspended. So it ain't doing you any good. Okay, and then in Volume 2, then depending on what style card you have, Now you can download all these manuals off the internet. I suggest that you look at them a lot longer than I'm taking a look at them because they're chock full of information. Right, benefits for active duty members. Okay, right, because all of these are the benefits that are determined by what kind of card you had based on the other part of the manual. And you get down here in just a little bit, and you get to benefits for uniformed service members, former uniformed service members. This enclosure describes the benefits for former uniformed service members and their eligible dependents. Former members are eligible to receive retired pay at age 60 for non-regular service in accordance with Chapter 1223, but have been discharged from their respective service or agency and maintain no military affiliation. Former members and their dependents are eligible for benefits under 1.6. And so, right, if I hadn't retired, because they have a separate one for retired, they have a separate one for medically discharged, they have a separate one for active duty. So who's left? Well, this would be, me. I'm a former member. Well, then give me the ID card that goes with enclosure 5. I haven't got it yet, right? They don't want to give you an ID card. They don't want to give you any kind of ID card. See, here's one for retired members. Now, the thing about being retired is you could have been medically retired, which again is what I think they're doing. All right, they're making us a TDRL, temporary disability retired list, and permanent disability retired list. These two different lists they have. That retire reserve benefits for members, retired reserves who have attained 20 credible years service, who have not reached the age of 60, and are not and receive retired pay as shown in Table 9. Yet they're retired. But they're not receiving the pay in number 9 yet. Well, can they get it later? Okay, so my point is, hey, we should have an ID card. And they're not giving it to us. And, hey, there's errors in your DD-214. And we need to get them fixed. And the one that can fix them is the one that can fix them is the secretary. Where did I have the secretary at? Let me go find that real quick. Hang on a second. Okay, so this is Title 38 United States Code, Section 503, Administrative Error, Equitable Relief. Come here, you. Cheapers just work a little bit slow. So, if the Secretary determines that benefits administered by the Department have not been provided by reason of administrative error on the part of federal government or any of its employees, the Secretary may provide such relief on account of such error as Secretary determines equitable, including the payment of monies to any person whom the Secretary determines is equitably entitled to such monies. So instead of arguing with benefits about benefits, we need to tell the Secretary, hey, there's an error in the records. Let's get that fixed first. Because I think if the errors were fixed, right, then the benefits would flow. The only reason they're not flowing is because there's a blockage in the frickin' record. If Secretary determines that a veteran, surviving spouse, child of a veteran, or other person has suffered loss as consequence of reliance upon a determination by the Department of Eligibility of entitlement to benefits without knowledge that it was erroneously made, the Secretary may provide such relief on account of such error as the Secretary determines is equitable, including the payment of monies to any person whom the Secretary determines is equitably entitled to such monies. Woo! It's like, holy smokes, man. Well, yeah, you need to talk to the Secretary. So forget everything else. How do you talk to the secretary? That's what this comes down to. Do you send them a mail? Do you send it to a secretary? How do you get a hold of the secretary, tell them that there's an error in the records? Well, that's what you do first, right? You quit making it about the fact that they only give you a 10 or 20, 30% for whatever some disability is. That's not the problem. No, there's an error in the records. Right? Your DD 214 is wrong. It needs to be fixed. Get that fixed first, and it will take care of all these other issues that, hinge on your status from the DD 214. No later than April 1st, Secretary shall submit. Okay, they had to put some report in, but not after December 31st, 2004. No report shall be required during the subject. I wonder why that is. They quit doing it in 2014. Nevertheless, so that's what I'm trying to do now. I'm trying to get a hold of the secretary and say, well, there's administrative error. I had a court case open in the Veterans Court, so I did it that way, right? But I wrote for somebody because if you have higher than 60% for any one disability or a combination of more than one, 70% total, yada, 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 then you already are eligible for this unemployability rating, which pays you 100% disability through the VA. Well, that disability doesn't have anything to do with your retirement. That's separate. But your retirement's being withheld from you because you don't have an ID card because of the DD 214. But you're getting 100% disability has nothing to do with being able to get retirement. You should be able to have both. Right? So this is what they're keeping from us. Somebody is dipping into that pie that's yours and keeping it for themselves. And they're doing it because there's these errors in the record. And we need to have our records squeaky freaking clean. Every jot and tittle. There are no blanks left blank. And everything is explained in its fullest. And, until you receive all your benefits, they haven't done it right. It's really that simple. But here's the basis of how it gets done. It's through Title 38, United States Code, Section 503. Now, if you want to take this to an attorney and see what they say, please do, right? I mean, if you have a reason to do it, go talk to an attorney. Say, look, according to Title 38, United States Code, Section 503, it says, for an administrative error, I can get equitable relief from the federal government or from the secretary. I want you to file a paper into the secretary administratively. I don't want to go to court. It doesn't need to be adjudicated in a court. This is an administrative error. How do you file a complaint to the secretary about this administrative error? And the error will be something to do with your DD 214. And if you watch the video I did before on the DD 214, I showed the manuals, that pertain to my particular case, right? That they're easy enough to find. You may have to ask for them somehow. Mine was for the Army, but the Air Force has them, the Marines have them, the Navy has them. And just look at the damn thing and see if the DD 214 has been filled out properly. Or just put in, that you believe that it's your belief that there's an error and you would like to have all the records looked at. Right? Because it says if a secretary determines that a veteran, surviving spouse, child of a veteran, or other person has suffered a loss as a consequence of reliance on a determination by the Department of Eligibility or entitlement to benefits, that isn't just disability benefits, right? They are administering your retirement benefits. So I'm looking at it. It's coming through the VA, right? Eventually, everybody is a veteran. And you don't have to be out of the military to be a veteran, as far as that goes. What is a veteran? You got veteran ball players. They play all the time. So, but even if it means that you are out, right? Eventually you're out and somebody's administering your retirement. And any disability you have, although now they're not giving you that because somebody's keeping it from people that have been retired. I don't think that people who have been retired have an easy time getting VA benefits. But if you have both, if you would please let me know, because these are the little things to get figured out. Okay, hey, moving on. Hang on a second here. Get rid of this one. Okay, so okay, I think we're working again. Anyway, so this was my idea. See, I don't have this situation, so I can't do it. But let's say that you had 60% or higher, or combination of 70%. I'll show you the laws that allow you to have these, and if you do, well, then there's your evidence, right? And so, if you have these numbers already, and you don't have the unemployability, they're only giving you maybe 60% instead of 100% disability payment, because that's what unemployability is 100% disability payment, $3,000 a month, ID card. You should take it. I'm trying to get it with 10% disability, because really it doesn't matter what your reason is, you just have to ask. But these are written into the law that if you have this, they're supposed to give it to you. Otherwise, you need to get somebody to agree with you that you get it, right? If you have less than these numbers. So I wrote this with the idea of somebody with 60% or higher. And in this case, it happened to be Bay Pines VA Healthcare System. She's down in Florida, I believe, Healthcare System Director. Right, so what did I do? Well, because the person knows, right, whoever it is, they know what hospital they're associated with. You can find them online. You put the name in, you'll find it, and then go under About Us and go to Leadership Team. And because my computer runs slow for some reason, eventually you get there. Hey, you get the guy's name. Right, there he is. That's who it is. Now, how exactly you're going to get this to him, I don't know, but that's who I'm addressing it to. Right, he's the administrator of this hospital. So if you're a patient of this hospital, then he's responsible for you. He owes you a fiduciary duty. RE, petition for relief from administrative errors. I'm happy to share this with anybody who wants to try to use it, by the way, right? But again, it's written for somebody that already has 60% or higher and wants to give it a shot, see what happens. Just we're going to go to the director, whatever they call them, administrator, and have them be our advocate. So, Dr. Russo, I am a patient of this VA healthcare system and the victim of an administrative error by the federal government or its employees that has resulted in the denying me my entitlements the federal government acknowledges by its own rules are owed to me. This denial is adversely affecting my health and welfare, and in accordance with law, I am requesting your advocacy on my behalf with the Secretary of the United States Department of Veterans Affairs. My health records in your custody evidence that my disability ratings exceed the rating percentage established by federal rule necessary for the immediate approval of my application for increased compensation based on unemployability. And yet my claim remains unpaid. The Secretary of the United States Department of Veterans Affairs has been empowered by Congress to provide equitable relief in accordance with 38 U.S.C. 503, Administrative Error, Equitable Relief, and as health has its own chain of command, including an undersecretary for health. I believe he can probably do it because, hey, he's an undersecretary. He can just do it. To the Secretary, I am asking you to use your authority to obtain an order for my relief from the admin error. After your review of the facts, I'm sure you will agree with me that I have all the qualifications necessary for the awarding of this entitled benefit. Only by error or omission on the part of the federal government or its employees could this entitlement be withheld. This is not a benefits evaluation requiring a benefit board determination. This is a matter of federal employees not following the book, and their wayward decision adversely affects my health and welfare. See, this is the great thing. We're just doing what the book says. right? Take the book to them, say, hey, this is what the book says. I'm serious. That's how you're going to make them have to conform to your will, because the book says what you said it says. Back to the reading. The laws of the United States are on my side, and I believe that this administrative error can be corrected if you officially report to your chain of command the circumstances causing this unjust condition, paving the way for the Secretary to do the equitable thing by his ordering my relief. I am attaching a separate page with the very few statutes and federal rules necessary to prove my claim that the federal government intended veterans with disability ratings, as mine, to be awarded increased compensation based on unemployability. Please review as needed and ask me for additional information you need, and then take action. FYI, I have already filed the VA Form 218940 for unemployability and have been denied. Right? So that's, there is a condition. You got to have put that form in. And that's just the form for increased compensation, asking for unemployability, because you've reached the numbers that are right in this law that I'm going to show you. So this is the second page for the doctor, right? You're going to put on the law that says that the Secretary can do what he's going to do, and then put in 38 CFR 4.16, total disability rating for compensation based on unemployability of the individual. 4.16, the total disability ratings for compensation based on unemployability of the individual. Where it says, provided that if there is only one such disability, this disability shall be rateable at 60% or more. So any one disability, 60% or more. And that if there are two or more disabilities, there shall be at least one disability rated at 40% or more, and sufficient additional disability to bring the combined rating to 70% or more. Then it goes through how it figures this out, and that's all in 416. Right? And then it says also in B of 416 that it is the established policy of the Department of Veterans Affairs that all veterans who are unable to secure and follow substantially gainful occupation by reason of service-connected disabilities shall be rated totally disabled. Therefore, rating boards should submit to Director Compensation Services for extra scheduler consideration all cases of veterans who are unemployable by reason of service-connected disabilities, but who fail to meet the percentage standards set forth in paragraph A of this section. The rating board will include a full statement as to the veteran's service-connected disabilities, employment history, education, vocational attainment, and other factors having a bearing on the issue. So this is me. I'm a B, right? Because I only have a 10%, and I'm saying, well, that's good enough. I say I get it just because I'm a veteran and I can't maintain substantially gainful employment, whatever that means. And when you look at the definition, for you to maintain substantially gainful employment means you have to be non-disabled. It's written right into the definition. I can't do it. I am disabled. My ears ring. Right? So if you've never gone to the VA before, right, first thing is, no matter what else you tell them your ears ring. That's 10% by itself. And then I didn't know this at the time, but then tell them that it keeps you up at night, because that's 30% for insomnia, because your ears ring. I've not done that part, but I did the other part, 10%, telling them, because, your ears do ring. I don't know anybody in the military whose ears don't ring. And so, it's 10% by itself. That makes you a patient of a doctor, right, or of a director who now has a fiduciary duty to you. That's my thinking. That's why I can give him mine, even though it's only 10%. I can give him the jots and tittles that say, yeah, but according to this, I'm still supposed to get it. And I got to work that out yet. But for somebody who already has a 60% or higher, just go ahead and send it in, right? If you want a copy of this, I'm happy to send it to you. Just change this up here to whoever it is, right? Make sure you change the director's name and They already have your records. That's the thing, right? This director has your records. What he doesn't know yet is there's an error keeping you from getting unemployability because you haven't told him you haven't gotten it yet. That's a health and welfare issue. It's not a benefits issue. It's because there's an error in the record. But you have to have filled out the VA Form 218940. Okay. I want to show you something else, though. Hang on, please. Okay, so I want to show you the one that I have going in the U.S. Court of Appeals for Veterans Claims, right? Because, hey, this is the United States Court of Appeals for Veterans Claims. This is an appeals court of the United States. If you click on that, it takes you to this page for some reason. And you can go down the full site, see the full site, or you can hit docket search. Really, that's all we're going to, but if you've never seen the site before, this is the site, United States Court of Appeals for Veterans Claims, docket search. And mine is 19-1910, which was put in way back in March. And they were already up to 1,910 for the year in March. I can't imagine what it is right now. But you can look at anybody's case. And I'm just clicking through. Going to go to full docket to see the whole thing, right? Come to this page, just say full docket. And it'll show you the whole thing. Right, that this is the case. Robert Allen Rytlewski, petitioner, versus Robert L. Wilkie. Right, I'm using my full legal name and he's not. And I put the first page in back in March. And I did a petition for extraordinary relief, which is in the rules to do. And it didn't take long for them to, order that my order was denied. Right, 328. Didn't take long to get a no. I put it in on the 20th. By the 28th, I got an answer. So I would try it again differently now, knowing what I know. But that didn't stop me at the time. I said, okay, well, I know what that means. I can still appeal because now I can ask to have a panel hear it, and you can ask to have the board hear it. And so I did all these things, get putting paper in and paper in and paper in, and eventually they issued. What did they call it? Anyways, a mandate, right? Put an end to it. Well, once they did that, I get to put in this thing called the EAJA application, which is Equal Application to Justice application, in which I said, and you'd have to read the law, I'm not going to have time to do it right now, but it says in that law that if the United States position is substantially unsubstantiated, that you can ask for these fees for defending your case or prosecuting your case. In this case, I guess you would say, because I was the prosecutor. And you can still also be considered the prevailing party because the United States, didn't participate in good faith, which is basically what I did. And so I put in an application, and then that's the first time. I put the first paperwork in March. Now in September, for the very first time, I finally got it to where I had the secretary had to answer me. Up until now, the secretary never put any paperwork. Just me in the court, me in the court, me in the court. But this EAJA made them have to put something in, and they put in a motion for extra time to file a response. Then I put in a motion for leave to file a bill of complaint in equity. Right, this is when I was first talking about equity just here a couple weeks ago. Get into all that stuff in a different video. But what I wanted to get to is they had to put in an answer. Finally they had to answer me. So what did they say? What was their reason going to be for denying me or giving me whatever it is that they were going to agree to or deny? Right? They had to give me an answer. And it said that pursuant to the rules for this Veterans Court, which is Rule 39, the Secretary of Veterans Affairs responds to my application for award of attorney fees and expenses under the EAJA Act. The court should deny the application because petitioner has not met the three predicated findings of the EAJA award. Oh, so you got to get these three to win. You need to be the prevailing party status. I said three, and then I put two. This must be just a mistake. The Secretary's position was not substantially justified, and there were no special circumstances that would make an award unjust. Prevailing party status requires some judicial action that changes the legal relationship between the parties on the merits of the claim. In other words, to prevail, a party must have received a judicial, and then they use this odd word, imprimatur. It's like, well, what the hell is that? What's an imprimatur, and why is it italicized? And what does tantamount mean? Tantamount to a judgment. So something judicial, tantamount to a judgment, but not necessarily a judgment, just something tantamount to a judgment, called an imprimatur. Well, that's interesting. What the hell is that? Well, as it turns out, that's a license to print or publish, especially by Roman Catholic Episcopal authority. That's what imprimatur is. It's an approval of a publication under circumstances of official censorship. Sanction, approval, imprint, sanction. Right? So basically, it's something, what it sounds like to me is something to do with ecclesiastic jurisdiction, not necessarily law jurisdiction. Because it's a sanction. That's what they do under ecclesiastic jurisdiction, is they sanction people. Oh, where in the hell was I at? Hang on a second. Okay, there it is. So, whatever that is. In other words, to prevail, the party must have received, so I must receive a judicial, something to do with the church, sanction, judicial sanction, tantamount to a judgment. Tantamount to a judgment in favor of the party on the merits of the original claim. And my original claim was, hey, I'm due to have, what happened? That I'm due to, sorry about that, I scrolled my hand across my keys. Right, but the original action was I said that I was due to have unemployability because I was a veteran and I asked for it. And the way I read the law, if I did, I could get it. Well, that hasn't been determined yet, but, that would be the sanction. So that would be one thing, right? So the idea is, how do you get this EAJA? That's one. The court has held that the petitioner is considered a prevailing party upon either the ultimate receipt of a benefit that was sought in bringing the litigation, i.e., award of the benefit, well, that would be okay with me, or a court remand predicated upon administrative error. I'm saying that's what they can do now, right? They were saying this is the way how I become the prevailing party is for the court to remand back to the secretary based on an administrative error, which I have since given to the court to say, hey, there's administrative errors. Here the court denied petitioner's petition for writ of mandamus because he failed to demonstrate indisputable right, blah, blah, blah. That was all at the beginning, right? But so that's why I would do it different now, because, yeah, that's what I was asking for at the time. I didn't ask for a writ of mandamus at the time. They're saying that I did, but I didn't ask for writ of mandamus. I asked for relief, equitable relief. I was denied. Okay. Hang on a second here. So anyways, because this is so screwed up, it's hard to make sense about what was happening when, and did something else cause it to happen, right? But that's why I wouldn't do it the same again the second time. I'm hoping not to have to do it this way again, ever. Just, do it more like I just talked about by going through the health side and say this is a health and welfare issue. Pointed out that DD 214 is incorrect. Can you please have the secretary look into it, see what they say? But if you had to go to court, well, this would be then it would be from the very beginning a complaint, more like what I did here, which is I finally put in a bill of complaint into equity. Because if the court has both law and equity jurisdiction, when you first go there, you're going to be in law jurisdiction, and the only way to get out of that is to tell them you want to go to equity. Right? Because because that's the way the courts work. It starts in law, and if you don't want law, you need to say, well, then put it in equity, because they have jurisdiction over both. So a motion for leave to file a bill of complaint in equity and a DD 214 to this court. This is what I did. This was the great thing about doing this in this court is that all this shit's free, right? It only costs $50 to open a court case. You can even have that waived, which I did. And then, all these papers are free. So it's like, well, it's a good place to throw things in and see what happens. Motion for leave to file a bill of complaint in equity in DD 214 in this court. The petitioner wishes to file a service copy of petitioner's DD 214. So that would be the long form service copy that you would get from National Archives. If you don't have a long form of your DD 214, you're going to have to get a hold of National Archives and tell them you want a copy. And just Google veterans records from National Archives, and it'll take you there, and you'll fill out a form. But you need the long form of your DD 214, which, when they sent it to me, was my service copy. Right? There's like 3 different copies that have the long form part on there. And one was I believe it was number 2 service copy. So anyways, because that's what it said, that's what I put on there. If you have one that says members copy and it's a long form, we'll put in members copy. Petitioner wishes to file the service copy of petitioner's DD 214 in this court records as evidence of errors and omissions in petitioner's discharge contributing to this dispute. When the petitioner's DD 214 is compared against the Army regulations mandating its execution to completion, there is no doubt that in equity the petitioner is entitled to many benefits and privileges that are now being denied petitioner, even if already being paid into the Military Retirement Fund and veterans benefits. Which was not a very well written sentence at the time. I must have really been in the spirit, but it's okay because, hey, I got the job done. Anyways, the idea was to say that when you compare my DD 214 against the regulations mandating the execution and completion of the DD 214, it's wrong. And no doubt that in equity, I would be entitled to benefits and privileges that are now being denied. See, the record's wrong. So in law, the record would say, well, the record says you don't get any benefits. We're not going to give them to you. That's the problem. The record is wrong. Not that I'm denied benefits. No, the record is wrong. So we need to fix the record. It's administrative, not judicial. So we got to get the record fixed, right? And the only way to do that is to go to equity, because law cannot change a record. It can only give you damages. It can give you money. It can't change a record. Only equity can change a record. Court in equity. As the Secretary has not yet acknowledged, authorized, or paid petitioner's claim for unemployability status, the petitioner feels compelled to file a motion for leave to proceed in this court's equity jurisdiction. Right? Because I hadn't done it yet. Well, I said I need to go to equity now to, get you guys to do it. Or this court's decree or order for the secretaries act in good faith for the United States and settle the accounts the petitioner has with the United States to include a valid DD Form 2S, which is the ID card. Or this court's decree or order for the secretary act in good faith for the United States, right, on behalf of the United States, and settle the accounts the petitioner has with the United States to include a valid DD Form 2S. Because all these different files, right, like the Your DD-214 isn't the record. It's just an abstract of different records that are all compartmentalized different places in the military. And never the twain shall meet except on the DD-214. So whatever that abstract is wrong, or extraction is wrong, that shows up in your DD-214, we need to go to the original record and have it fixed. Well, that's what the secretary can do. We're not getting to see those records. We only get to see the DD-214. Yada, yada, yada. I don't mean to harp on this stuff, but this is the jots and tittles, man. This is what they're doing, right? It's not that difficult to see. Hey, they're using an error in the records against us. And if we don't say something, they're going to continue to use the errors in the records against you. What else did I send them? I sent a bill of complaint and equity, pointing out the things that were wrong. I don't want to read all these right now. I mean, if you want to read them, they're all on here. This is the point. This is public record. Right? But I finally got to a point where I put in, just the other day, after the secretary's answer was put in, right? So, come on, where are you at? The secretary put their answer in about why I shouldn't get whatever I should get. And I had put in something else that hadn't quite made it to the docket yet. Right? They didn't want to put it in the docket. It's because I had mentioned on there that I wanted these people round up and put in a FEMA camp, probably. Probably wasn't a good idea. But it's on there. So I said, okay, well, I know what I'll do. I'll just lighten it up a little bit, and I'll resubmit it as an objection to their answer. Right? And I had found this maxim of equity that you should Google maxims of equity if you've never done it, and go to Wikipedia and read what they are. One of them is equity delights to do justice and not by halves. Right? The idea to going to equity is once you get there and you get equity to agree with you that you've been wronged, then those people who are very learned in the law that have the authority to, use this equity jurisdiction are supposed to get you a complete remedy. Everything is supposed to be fixed. Not, don't leave anything. Not by halves. Complete. So, anyways, objection. Secretary's EAJA response is a breach of the public trust. The Secretary's response omits petitioner's full legal name, which it did. I probably should have shown that, but it didn't have my full legal name on it as the petitioner. I had a guy with a middle initial. Concealing the real party and interest by the pseudonym Robert A. Rutluski in contempt of this court's order that the Secretary answer petitioner's EAJA application. The Secretary's agents instead simulated a legal process and stole the identity of the real party and interest. Right? The court told them to answer, and when they answered to the middle initial, not to my full legal name, although my full legal name is on the docket. So this is proof to the court. It's like, well, dude, it's on your docket, Robert Allen Rutluski, and they put Robert A. Rutluski. That should be contempt of your order. Because they didn't answer the court. Right? They committed contempt. And simulated a legal process. And stole my identity. The Secretary's underlings conscious decision to conceal petitioner's identification in a matter of official business is an act of bad faith and a breach of the public trust, rendering petitioner insecure in his person's papers, houses and effects from unreasonable seizure in offense of the Bill of Rights. Petitioner reminds the court of the evidence provided the court that proves there are administrative errors in the petitioner's DD-214, because I gave him a copy and showed him what was wrong, and his other official records. The Secretary has the authority and the duty to have all these records corrected and provide equitable relief. The United States intended certain entitled benefits and privileges to be provided petitioner for honorable and faithful service, and the petitioner claims all of them, requiring the correction of all his service records. Prayer for relief from the court's equity jurisdiction. Should probably said in the court's equity jurisdiction. Not from, but in the court's equity. From the court in its equity jurisdiction. How do you use those connector words? Petitioner prays the court adhere to the maxims of equity and delight to do justice and not by halves. So the funny thing is, when the other one I tried to put in, which I didn't put in, right, was like a day or two after this one in, so it didn't go in for quite some time. But the day I put this one in, which was late in the afternoon on the 10th, it's only the 12th day, so, first thing in the morning on Friday, they popped this thing into the record. So that's encouraging. And there we are. Now it's on the record. Put it on 1010. The secretary's peeps had their say. I had my say, and now it's time for the court to decide. But if the court has equitable jurisdiction and it was to agree with me, well then I can just sit back and let them do it. They're the ones that, are learned in the law and know what needs to be done. I'm just guessing. So if I was going to do that again, I would do it again, starting with things at the bottom, pointing out the errors in the record, give it to the court, see if they agree. They can remand it down to the secretary, tell him to fix the record, and away we go. Anyway, hey, those are the things I wanted to show. I don't know that there's much more I could tell you, other than, well, this is interesting. I do need to show you this. All right. You can download this yourself. It's the Military Retirement Fund Audit Financial Report. They audit it every year. And in the first 20 pages or so, it'll tell you lots of interesting things. And if you like charts and graphs, it has even more. But, it tells you things like, so during this last year, this fund received $18 billion from cost payments. 90 billion basically from the U.S. Treasury, and earned 30 billion in investment income. So 90, 30, 120, jeepers, $140 billion, went into this last year, but it only paid out 54.7 billion in benefits. Well, where'd the rest of it go? I mean, that's 40%. Where's the other 60%? And then I talked about generally this is funded non-contributory defined benefit plan that includes non-disability retired pay, disability retired pay, survivor annuity programs, and combat-related special compensation. I say that's what this, what they did with Social Security is. But this is where I can show you where it says it. But all of these are paid by the DOD. None of these have anything to do with disability pay. This is disability retired pay. You could have both of them. And it says how it's figured, right? It's basically 2.5% times the number of years of service, payable at age 60 as a pension. That's the way I read it. I just don't know who to take it to. And, well, now I do know who to take it to, so we'll go ask them. You got non-disability retired pay. I wasn't going to read all these. Disability retirement. A military member in active component or on active duty more than 30 days who is found unfit for duty is entitled to disability retired pay if the disability, based on accepted medical principles, is permanent, is incurable while entitled to basic pay, or is incurred while entitled to basic pay, is neither the result of member's intentional misconduct or willful neglect, was not incurred during a period of unauthorized absence, and the member has a disability rate at least 30% under Department of VA. So this is one of the reasons I don't want to give you that thing, because, if you had that at least 30% VA, you could get this other one to kick in. Reserve retirement, 20 qualified years. But they never really tell you what a qualified year is. For members not under BRS, retired pay is computed as base pay times 2.5% year service. I had 8 years in, that would make 20%, so my retired pay would be 20% at age 60, payable as a pension due to my service. And if it isn't that, well, then I must have been disability retired, and I don't know it. Where's the one I really wanted to show here? The VA provides compensation for service-connected and certain non-service-connected disabilities. These VA benefits can be in place of or in combination with DOD retired pay. Well, why would you want it to be in place of? No, I'll have it be in combination. Can I have it that way instead? But through 2003, we're not fully additive. Well, it's not 2003 anymore, so now they are fully additive. You can have both VA pay and retired pay, and they're additive to each other. VA compensation for unemployability, or 20%, 40%, whatever the hell you had. I'm just saying you can claim unemployability if you can't make $36,000 a year working, then you can have it as unemployability, and you're just supposed to have to ask for it. That was my premise from the beginning. And if I ever get it figured out, I'll shorten it up and go do it again and show you how to do it. But you don't need to be 60% or anything else. You just need to have served and then not be able to hold down a job for whatever reason. Right? As long as you don't mess up, the Uncle Santa doesn't have a problem giving you $36,000 a year. Well, here was the thing. Beginning in 1946, Congress enacted a series of amendments to the Social Security Act that extended some benefits to military personnel and their survivors. Now, remember, to get these, you have to have the ID card, right? This is why I got to have the ID card if I'm going to get this. These gratuitous benefits were reimbursed out of general fund of the Treasury. The Service and Veterans Benefits Act brought members of the military into contributory Social Security system effective 1957. They got the old age insurance plan in there. One feature of this, unique to military personnel, grants a non-contributory wage credit of $300 for each quarter. It was between 56 and 78. Then they went to $1,200 per year. Well, that's still $100 a month, right? Basically $100 per month. They're going to contribute while you're on active duty into some gratuitous benefit in Social Security that you're only going to be able to claim if you have the ID card from DOD to have your benefits from DOD, because this is a retirement benefit. It's not a disability benefit. There you go, right? So, it's much deeper than this, but that's enough for today. This is why I'm taking all this information and, trying to get a remedy that now is either going to be through this, going through the frickin' court, or making it a health and welfare issue with the administrator of your local facility and tell them that the DD-214 is wrong. So I'm going to do a video again on my DD-214 and do a much better job explaining it now that I know what I would use it for. Just touching base on things today. And because of that, I'm going to leave it there and call it a day. But I am going to ask you to donate because I don't have it figured out yet. And it's the middle of the month already, and I got to pay rent again soon. Please help if you can. And I'll let you know what happens. Leave it there. You guys have a great day. See you.